I'll hand you over to Nigel now, who will be discussing ePrivacy.
Thanks very much, Ben. So now we're going to look at the regulations relating to cookies. First, why is it important? Well, first of all, as a result of changes brought in by the GDPR, it's no longer possible to rely on implied consent. You remember that many of the cookie banners rely on an implied consent, that just carry on browsing is consent. That's no longer possible following GDPR. It's also very high on the regulator's agenda in relation to cookies, because whilst I guess many of us don't really worry too much about cookies or suffer from cookie notice fatigue, just click through, there's an increasing number of complaints that are made to the regulators, nearly 2,000 in the past year. Also, the ICO is currently investigating the ad tech sector, which is largely driven by cookies. And whilst many of them are innocuous, others are highly privacy invasive, involving systematic monitoring and tracking across devices and so on. So they're concerned about the intrusive nature of much of this technology. Also, of course, because of the high level of GDPR fines, there's nothing like an eye-watering fine to bring a matter to the agenda. We've seen very substantial fines, for example, from the French regulator on Google and Amazon in relation to their use of cookies. 100 million euros in the case of Google and 35 million in the case of Amazon. And finally, we've got the developing new law in relation to ePrivacy, which I'll look at in a moment. So what is the law on cookies? Just a quick reminder of what it is. The current law is set out in the European ePrivacy Directive, and in the UK regulations, electronic communications regulations, fondly known as PECA, Privacy and Electronic Communications Regulations. And actually, the law doesn't refer anywhere to the word cookies. It is the cookie regulation, but it doesn't use that word because it's trying to be technology neutral. Basically, the regulation covers any technology that can access or store data on a user device, whether that's a smartphone, smart TV, or any other device. And it also covers other technologies like tracking pixel GIFs, which are often used in email marketing to monitor whether emails have been opened, which can provide valuable analytics. So the key requirement under PECA is when you deploy a cookie, you must do two things. First of all, provide clear and comprehensive information about the purposes of the cookie. And also you must get consent of the user to use the cookie. There are a couple of important exceptions to this. The most important one for our purposes is a cookie that is what's called strictly necessary or essential for the service requested by the user. So cookies that are strictly necessary do not require consent. Cookies that are merely helpful or convenient or that are only essential for your purposes as opposed to the users will still require consent. So for example, cookie used to authenticate a user or to remember items in a shopping basket or remember language or other preferences are regarded as strictly necessary, but cookies for analytical purposes and advertising are non-essential and need consent. So an important thing to bear in mind when looking at PECA as against the GDPR is that consent is needed for cookies whether or not the cookie data involves personal data. So it may be completely anonymized and non-PII, but it still needs consent. If it involves personal data as well, such as device ID or username, browsing details, then it will be subject to GDPR as well. And under the GDPR, you always have to have a lawful basis for processing of data. Typically for marketing, that would be either consent or legitimate interests. But when it comes to cookies, where cookies are deployed and personal data is involved, then PECA effectively trumps GDPR, which means that If consent is required under PECA, then it is also the appropriate legal basis for processing under GDPR. So there's some debate about this in the ad tech sector, where many argue that whilst consent is needed for the initial cookie, it isn't necessarily needed for any subsequent processing of the same data. That could rely on legitimate interests. However, I have to say that at the moment, the regulator doesn't wholly agree with that. Although the actual legal position is not completely settled. So what do we need to do then in relation to cookies? The first thing is to carry out what's called a cookie audit, to make sure you know exactly what cookies are in use on your site, what the purpose of each one is, and the duration. In this audit, you can identify any cookies that are strictly necessary, as we discussed, that don't need consent, and also any third-party cookies. In the case of third-party cookies such as Google Analytics or affiliate networks, while it is the third party that requires the consent, in practice, the third party requires that the site owner gets that consent on their behalf. So if you're operating a site that has third-party cookies, then in practice, it's your obligation to get the consent for them. Review the consent mechanism you have on the site to make sure it's compliant. Everyone seems to do this differently. Some do it better than others, and some are more compliant than others. More on that in a minute. Good time to have a look again and update your cookie policy. Make sure that it meets the transparency requirement that we've discussed. And importantly, make sure that the policy is consistent with the cookies that are actually in use. There's no one-size-fits-all policy here. It all really depends on what cookies you've been implemented on your site and the purposes. And you may also need to carry out a DPIA impact assessment under the GDPR if the cookies involve personal data and are used for profiling or other similar purposes. And even if it's not strictly required under the GDPR, it might be good practice to do so to help manage any risks that may be identified. So how to get this consent? Because the consent required under PECA follows the GDPR standard, meaning that it has to be freely given, specific, informed, and an unambiguous indication of the end user's wishes through a clear affirmative action. So a couple of points on this. First of all, there's no need, as I've said, to get consent for strictly necessary cookies, and therefore there's no need for a pre-ticked box for that either. Where consent is needed, do not use a pre-ticked box because that would not be a valid consent. Consent has to be signified by a positive step, such as ticking a box. And don't bundle multiple consents into one. Ideally, there should be a facility to give granular consents for each cookie or each category, and also an accept all or reject all option. The next one is important. Do not set the cookies before you've got the opt-in. So the cookies shouldn't be on by default, asking for an opt-in. They should be off by default and then only dropped when the consent has been given. So you might need to check with your technology team that they're operating correctly in that way. And then, as I said, provide clear and comprehensive information, because if the information is not clear and fully comprehensive, then it won't meet that transparency requirement, but it also will undermine the consent because that won't be fully informed. And also it's good practice then to have a facility for users to revisit the consents that they've given, or perhaps come back and give consent. So there are some good models in that as well. Moving on to look briefly at the new ePrivacy regulation, which has been knocking around for quite some time. It's been on the horizon since the GDPR came in. The idea was that it would come in at the same time. It addresses a number of issues, but the news is that the text has finally been agreed in February this year, and it is now going to the European Parliament, so it's expected to happen. The objective was to update the ePrivacy Directive, which is now 20 years old, and bring it in line with the GDPR. So it does align with the substantial fines under the GDPR, whereas at the moment fines under PECA are limited in the UK to £500,000. So there's a big difference there, but the end result will be that the fines are aligned. And also, like the GDPR, the new ePrivacy regulation has extraterritorial application. So it will apply to all businesses outside of the EU insofar as it relates to users in the EU. But unlike the GDPR, it doesn't require those users to be specifically targeted. So that's quite a broad extraterritorial application, triggered as soon as you, for example, have cookies which implicate EU users, regardless of whether there was an intention to direct your activities at them. So far as the cookie requirement itself is concerned, there's not a huge change. There's still a need for affirmative consent, except the number of circumstances are a little bit broader where you don't need consent. It will extend to, for example, cookies for audience measuring or web analytics, or for IT security purposes, a little bit broader. And the regulation is going to allow consent to be given by settings within the browser. So, for example, you could whitelist certain sites that you approve for cookies. Browsers may need to develop new facilities for that. And also, users who have given consent have to be reminded within 12 months, every 12 months, of their right to withdraw. So not huge changes in relation to cookies, but maybe some helpful developments. There are lots of other changes in the ePrivacy regulation which are just outside of the scope, but something we'll look at on another occasion. And once the ePrivacy regulation is brought in, there will be a 2-year transition period. So a bit like the GDPR, we'll have a bit of a warning time, but it's obviously good now, if you're not already comfortable, to make sure that you're compliant in terms of the way things are at the moment. As far as the UK is concerned, following Brexit, we won't in the UK automatically be subject to the ePrivacy regulation, but I think it's quite likely that the UK government will make changes to PECA to broadly bring it in line with the ePrivacy regulation, especially in relation to any more business-friendly sections. Also, because of the extraterritorial application of the regulation, which I mentioned, it's quite likely that many UK businesses will be directly subject to the privacy regulation anyway, because they will be addressing end users in the EU. So that's a bit of a lightning roundup of the regulation on cookies.